Hello, I'm Jim Ganther.
And I'm Randy Henrick.
And today we'd like to dispel some of the confusion that has arisen concerning the Military Lending Act, or MLA. Randy, what is the Military Lending Act and what does it do?
The Military Lending Act was enacted in 2006 and amended in 2013 by the Congress to protect service members from alleged financing abuses. It originally covered only payday loans, vehicle title loans, and tax refund anticipation loans. But in 2013, it was amended to more broadly cover consumer credit.
Randy, what does the MLA require of dealers?
Well, if a transaction is covered by the MLA, dealers have to calculate a separate military annual percentage rate, which is different from the Truth in Lending APR that we're all familiar with. It includes aftermarket products, fees, and other things. They also have to give the covered service member extensive oral and written disclosures about the rate and the transaction, and it prohibits putting certain requirements on the service member, including any arbitration clause.
Who does the MLA cover? What is the definition of a covered person?
Well, under Department of Defense regulations that were issued effective October 2016, the definition is very broad. It covers active service duty members, service duty members who are on 30-day orders, certain National Guard members, and certain reservists. There is a way to determine whether somebody is a covered member, because dependents are also covered, and that's by going to the Department of Defense's Military Lending Act homepage, or by using a consumer reporting agency credit report designation to find out if a person is a covered Military Lending Act member.
Does the MLA specifically apply to motor vehicle financing?
The MLA contains an exemption for motor vehicle acquisition loans. However, to fall within that exemption, you have to look at what's being financed. So, for example, if a consumer were to take cash out of a motor vehicle lending transaction, the cash it took out would not be covered in the whole transaction, would fall outside the exemption and be covered by the Military Lending Act. The recent changes made by the Department of Defense relate to what is a covered transaction under the Military Lending Act and what is an exempt transaction for motor vehicle financing.
How did the DoD interpret this exemption in the past?
In the past, the financing of any product or service that related to the vehicle would keep the transaction within the exemption, and the Military Lending Act would not apply. But if, for example, a consumer took cash out of a vehicle acquisition loan, that would put the transaction outside of the exemption, and the Military Lending Act would apply. However, generally, things like GAP and credit insurance were considered related to a vehicle, and therefore the Military Lending Act did not apply if the transaction included GAP or credit insurance.
The DoD recently changed its interpretation of the motor vehicle finance exemption. How does that change affect car dealers?
Well, the change is significant. What they said was, to be within the exemption, it is a credit transaction that finances the vehicle itself and any costs expressly related to the vehicle, provided it doesn't cover any credit-related product or service. So that if a credit-related product or service, and I think that would include GAP and credit insurance, is financed, the transaction is outside of the auto vehicle financing exemption and would be subject to the Military Lending Act and its requirements for disclosure, for calculation of a military APR rate, and some very punitive penalties.
Well, Randy, how can dealers comply with this new interpretation?
I think there's two ways to comply. One way for certain compliance would be not to offer GAP or credit insurance, but that's not a viable answer. I think the best way for dealers to comply is to offer the GAP and credit insurance products, but not offer them to any covered Military Lending Act member. Now remember, you can have a safe harbor on finding out whether a person is a covered MLA person by going to the Department of Defense's MLA webpage or getting a notation from on a credit report. You're going to have to do this for every customer because the definition of dependents is very broad and people may not even know if they're a covered person or not. But I think if you do that, you'll have a safe harbor, and you can tell a covered person that the reason you're not able to sell them the gap or credit insurance is because the compliance costs that the federal government is imposing on you are so substantial that you made a legitimate business decision not to be able to offer these products to covered MLA persons.
Randy, what are the penalties if a dealer does not comply with this new interpretation of the MLA?
They're very substantial. It's a knowing violation is a federal criminal law violation that provides for fines and up to 1 year in prison. Civil liability includes actual damages or statutory penalties of $500 per transaction, recoverable in a class action, along with punitive damages, attorney's fees, but most significantly, the contract is void from inception, meaning that a customer who had signed a contract and not received the disclosures and the military APR calculation could come back in 4 to 5 years and say, thank you for the test drive, here's your vehicle back, give me all the money I paid.
Well, those penalties are, as you described, very substantial. And if I understand you correctly, actually complying with this new interpretation of the auto finance exemption is virtually impossible for a dealer to do?
Yes. The 2015 regulations amended a very complex calculation methodology that needs to be used for the military APR. The disclosures require both written and oral disclosures, the use of a toll-free phone number, and other things that the average sales or F&I person is just not going to be able to do. And it's questionable whether there's even accurate software to cover the calculation of the military APR. So the compliance costs would be excessive and the compliance burden would be as well.
So to summarize, to avoid the burden of compliance and the penalties that would flow from non-compliance, you suggest two approaches. One is don't sell gap or credit insurance, or don't sell gap or credit insurance to everyone who's covered by the MLA. Is that a fair summary?
Yes, and I think to make sure that if you choose the second option, to make sure a customer is not covered, you need to check one of the safe harbor databases, because the definition of dependence is very broad and covers many people that you might not otherwise think of as dependents, possibly including spouses who are getting alimony in a divorce or separation proceeding. So to be compliant, to cover yourself, you want to, I think the best choice is to sell the gap in credit insurance to all customers except for covered MLA persons, and check each customer against one of the safe harbor databases. The Department of Defense's Military Lending Act page lets you do it for transactions going forward. All you need is the customer's name, address, date of birth, and social security number, or you can get it as a notation on the credit report you pull on the customer from a national consumer reporting agency.
Thank you, Randy. Regardless of what the courts or Congress might do with respect to this issue, it's obviously best practice to assume that the DoD's interpretation of the MLA, as adjusted, is controlling. It is right now what we have to live with. The best practice would be not to sell gap or credit insurance to covered members under the MLA. Of course, what we offer here is our opinion. It is not intended to be legal advice in any state or for your particular circumstances. For that, we always refer you to your own local counsel. Thank you for your time, and we will do our best to keep you posted as this situation develops.